Hello, it's Philip Taylor speaking, and I'm looking today at a book from Hart Publishing. It's in their excellent series of very thought-provoking books. This one is called British Overseas Territories Law. It's written by Hendry and Susan Dickson, which you can see here. Maroon cover, about 350 pages long. The contents are very useful. You can see there a few bits and pieces. I would draw attention to the appendix at the back, which lists all of the territories that are covered, and what we've got, of course, are cases, and we've got, as usual, the standard chapter headings and very useful and detailed footnotes. And right at the back we have a very detailed index. I think this is a very worthwhile book, coming as it does at a particular time in our history. The title we've given it is, at last, the up-to-date book on the law of British overseas territories, and the first in 44 years, and that's exactly what it is. The gradual disappearance of the British Empire and its subsequent metamorphosis into a Commonwealth of Nations continues generally to be a topic of interest to all of us, not just to historians, but of course to many members of the public generally, and especially to us as lawyers. We were therefore rather surprised to find out in the foreword that it's the first study in 44 years on the topic of the law in specific areas, that is to say the law and practice relating to British overseas territories, and they're all listed in the work. As the learned and expert authors Hendry and Dickson point out, the great authority on this subject was Sir Kenneth Roberts-Ray's book, Commonwealth and Colonial Law, and the title, of course, is not particularly user-friendly or appropriate today. But that was published in 1966, when it was a rather different world from 2011. And we believe this is a worthy successor because it contributes a much needed, fresh and topical examination of this somewhat overlooked area of law. It's not one that I've come across much in practice, but I do find it interesting both as a student of history and, of course, as a barrister. The old empire is consigned to history, but there are still 14 British overseas territories out there, not just obscure and remote ones like Tristan da Cunha, Pitcairn and South Georgia, not to mention a large chunk of the Antarctic, but densely populated, thriving territories with dynamic economies, based largely on tourism and financial services such as the Cayman Islands, British Virgin Islands, Gibraltar and Bermuda. As is pointed out by the authors, none of these territories so far have applied for independence, enjoying as they do numerous advantages via their linkage with Britain, including the much envied benefits of self-determination. The introduction to this work contains definitions of the salient terms such as colony, possession and territory, bit emotive, and there's a lot of political correctness around today concerning these words, so treat them with care. The definitions can be rather wide, of course, and complicated, but as the authors state that, quote, all British overseas territories fall within the definition of British possession in the Interpretation Act of 1978, that's our starting off point, and practitioners who deal with cross-border and or offshore financial services issues would do well in our view to acquire additional background information on those territories from this fascinating read. It's referred to as a manual of law and practice, which I think is what it is. It provides a comprehensive examination of a wealth of issues pertaining to British overseas territories, from their sources of law and human rights protection to the nationality and status of their respective populations, their financial arrangements and their relationship with the EU. There's a very useful appendix at the back, which I've indicated, which deals and looks specifically at the particular areas, British Antarctic territory, for instance, mentioned there. Legal practitioners, I think, not to mention historians, will no doubt pounce on this timely book, already regarded as a definitive authority, because of its importance in this area of law, which is stated as at October 2010. And I think the authors have taken into account a very useful series of developments since then to give us the most up-to-date statement on this area of law after a 44-year intervening period. So thank you very much to all concerned. I'm particularly keen that Hart Publishing have taken this on, because it's an area that I think we will all be very grateful for as practitioners. So thank you to all concerned. Bye bye.